Are you planning to bring your spouse to the United States? In this video, we break down everything you need to know about the U.S. spouse visa process, eligibility requirements, and how it leads to permanent residency, leading to better prospects for you and your family. If you are a U.S. citizen or a permanent resident and wish to bring your spouse, i.e., your husband or wife, to live with you in the United States, you can apply for a green card, making them a legal permanent resident. This is the first step to kickstart their immigration journey to the U.S. There are several steps that need to be followed in order for the spouse to acquire legal permanent residency and immigrate to the United States. The applicant will be required to file an immediate relative petition, meaning Form I-130. This is the first step in establishing a relationship between the U.S. citizen and the beneficiaries. If the applicant is residing outside the U.S., the petition moves to the National Visa Center for processing once the I-130 is approved. The petition will then be forwarded to the appropriate U.S. consulate when a visa becomes available, and the relative, i.e. spouse, will be notified about how to proceed. Upon approval of the application at the consular interview, the visa is then issued. Upon entry into the U.S., the spouse will be admitted as a lawful permanent resident under a CR1 or IR1 spouse visa, which is a green card that allows someone from another country to live in the U.S. with their spouse, i.e., a U.S. citizen or legal permanent resident. If you've been married for less than 2 years, you will get a conditional resident green card, which is only valid for 2 years, after which the foreign spouse applies for removal of conditions to receive a 10-year green card. If you've been married for 2 years or more, no conditions will apply. After having acquired the status of a legal permanent resident via green card, the spouse of a U.S. citizen who resides in the United States may be eligible for naturalization on the basis of his or her marriage. In order to qualify for this, number 1, the applicant must be living in a marital union with his or her spouse for at least 3 years preceding the time of filing the application. Number 2, the applicant must be continuously residing in the United States as a legal permanent resident immediately preceding the date of filing the application. And number 3, the applicant must be physically present in the United States for at least 18 months out of the 3 years preceding the time of filing the application. The USCIS processing times for Form I-130 generally range from 12 to 16 months. It is important to note that these timelines are estimates and may vary differently for each case, depending upon the embassy processing times. Prospective clients can contact us at the provided contact numbers or email below to set up an appointment for their free initial consultation. Our team will guide you through the entire process, ensuring a smooth and successful application. Absolute Legal Works offers a full range of U.S. immigration law services. It has a collaboration with the Pakistani law firm Uscis Law Chambers. This video is not to be considered as specialized legal advice and is for general information purposes only. We encourage every applicant to contact us to seek specialist legal advice before embarking on their U.S. immigration journey.